Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime, and we are certainly doing that tonight. It is not just a tagline, it is our reality when we say we've got the best guests in true crime, and we are back. Took a little time off to see the family out west, and did a couple of book appearances, and it was fun and went well, and always nice to breathe that smoggy air in Los Angeles. But we are back on the Donna Adelson pre-trial shows here. We're literally 1 month away from the start of this trial. Actually, 2 days less than a month, whatever that is, 28 days, 29 days. So that's how far away we are from the start of the Donna Adelson trial. And of course, as you all know, she is charged with first-degree murder and the conspiracy to kill her ex-son-in-law, FSU law professor Dan Markel, and things certainly heating up. There were a bunch of motions filed last week when we were away, and we're going to go through them tonight. So prepare to enter law school this evening with our guests, and we'll see if Singer and company really know their stuff, because we're looking at motions. So John Singer, without further ado, as you know, he is co-founder of Singer Deutsch LLP and a graduate of Georgetown Law. He was designated a New York super lawyer for literally 300 years in a row. I can't even list all the years. Fantastic guy on top of it, and diehard all things New England fan. Next up, Anna Cominsky. She is the director of the Criminal Defense Clinic at New York Law School. She teaches 3 other experiential learning courses there, and she's also named the managing attorney of New York Law School Legal Services. She manages the day-to-day functions of the school's in-house law firm, so not just a professor, but also a working lawyer. And then last and certainly not least is Stephen Webster. He is one half of Webster and Baptiste, attorneys at law in Tallahassee, and Stephen was Dan Markel's post-divorce attorney. We'll go around the clock here. John Singer, you were telling us off air stuff that I shouldn't announce, but your wife, she's not into this case the way you are into this case. We are now less than a month away. How much anticipation do you have ahead of this trial starting?
I'm looking forward to it. I think it's going to be a lot of the same that we saw in Charlie's case, a lot of the same witnesses. They unfortunately, the state has to prove its case all over again from start to finish. They have to presume that this particular jury pool is not familiar with the case, so they have got to do the same thing all over again. We're going to see the same people that have testified in trials 1, 2, and 3. So there'll be a lot of evidence that we've seen before, but I'm looking forward to it in the sense that there's going to be new evidence specific to Donna, things we hadn't seen in Charlie's trial or in the Magmanua 1 and 2 trials. So I'm looking forward to the new evidence. I think that some of the motions that have been filed to date, I mean, I guess we'll get to those, but I think the majority will get denied in their entirety. And it looks like the judge is ready to rock and roll in 28 days. So looking forward to it very much. And
I know you've got a heavy workload, a lot on the docket yourself, John Singer. Any chance that you're going to be sneaking peeks at the stream while you're in your office during this trial?
For sure. I mean, my partner and I are both into it. He not as much as me, but we'll have it going during gavel to gavel coverage. And while we're not otherwise occupied, we'll be looking at it. And there's certain witnesses that I think we can skip. Some of the law enforcement folks who we've heard before are not really on our radar for listening to that kind of testimony. We've heard it, we know it, we know the facts. Some of the more interesting fact witnesses, though, will be circled, and we'll certainly listen to those, Wendy Adelson and others.
And I've got to ask, John, is your law partner, Mr. Deutsch, is he a New England Patriots fan or no?
No, he's from your part of the. He's from your neck of the woods. He's from New Jersey. Rangers fan, all that stuff. So yeah, we don't talk sports much.
You stay off of it. Anna, I always ask the hard questions. To you, I'm literally 28 days away. You're a professor. You're also a practicing attorney. Kind of pull back the curtain for us. I mean, what is going on right now? For full disclosure, I did reach out to Dan Rashbaum via text saying, hey, it's a month away. How you feeling? Did not hear back, but I only did this a few hours ago. But I wanted to get an idea what his mindset is like. And I've talked to him a couple times, and he's busy preparing his case, obviously. But Anna, what's going on, on the defense side of things right now with basically 28, 29 days to go?
I mean, this is really crunch time, right? For both sides. This is the squeeze between when, the case takes so long to really develop. Like the arrest, although it feels so awful to the defendant, of course, that is just the start. And in a case like this in particular, right, when you're talking about a murder case, these cases take a long time to develop. And what I really see here, in addition to sort of that squeeze, an added layer to that squeeze, so to speak, is the fact that you've got all these other trials where the attorneys have to look back at all the testimony from all these other trials, all the exhibits, because we know that that's going to be used again. And so they're sort of, it's a benefit to the defense being able to see what a lot of the witnesses are going to say, but it's also just a mountain of evidence that they have to comb through and really start digging deep and getting ready for this trial that's going to happen in a very short amount of time.
Yeah, it's interesting. John Singer happens to have a photographic memory, so it must be easier for him. I mean, John, is that true? When you're preparing for a case, can you look at stuff literally a single time and it's just locked away in your memory? You told me you never use notes, right?
I don't use notes for openings, closings. For dates and numbers, I have a really good memory and concepts. So I have a good memory, but I think Anna's right in the sense that it's a positive and a negative. I mean, on the one hand, Rashbaum knows already what many of the witnesses are going to say because they testified 3 times. Wendy is a bit of a wild card because she vacillates from truth to lying in such a facile manner. So we don't know what's going to come out of her mouth. But law enforcement, their stories are consistent. And for the most part, they know what they're going to say. So that's good for him. But at the same time, if they do deviate from prior testimony, he has to be prepared, his team does with transcripts, to impeach people with things they've said in prior trials. So he's got to be nimble in that regard, because in the off chance that someone does deviate from what they said previously, he's going to be ready to sort of drive a wedge through that testimony and highlight that contradiction.
By the way, Courtney is right. Joel made an earthquake in LA. I don't know if I made it, but I was there when it happened. And the epicenter was actually pretty much underneath Space Coast's building. And so he said it was crazy. And he's lived in LA his whole life. He thought it was the big one. Phantom 6000, what's up, man? Hello from Mexico. Couldn't miss STS. Love to see you. We got to catch up, Phantom. He's down there promoting a fight between Floyd Mayweather and John Gotti. He is a fight promoter. So good luck to you. It's a pretty cool fight. But yeah, the epicenter of that quake, which I happened to sleep right through, was literally where Space Coast lived. He said he thought the big one, that it was the big one. And then on LA radio, which I like to listen to when I'm out there, all they're talking about is that the big one is coming. So that side of my family, hunkered down, bear down. We have hurricanes to worry about here. You've got earthquakes. Stephen Webster, to you, let's take the state side of things. I mean, you've got Georgia and Sarah, Jack Campbell. I mean, they've been through this so many times. I mean, even Rashbaum is now going to be going through this a second time. Is it possible that you can get a little complacent, maybe, and not reevaluate and look at the material as closely as maybe you should, because you say to yourself, I've done this a bunch of times already? Is there a fear of complacency?
I think that's a legitimate fear. I don't think it's realistic in this case. Georgia's lived this for 10 years. Sarah Catherine has lived it for quite a few years now alongside. They have a multitude of people inside the state attorney's office who are working on it behind the scenes, other attorneys, investigators. Jason Newland has worked tirelessly. So that's certainly something you would, I think, be worried about, that it becomes kind of stale. But I think like John said, there's enough new information, and there's enough information now that's particular to Donna. And frankly, given kind of Donna's role and who she is as a person, I don't think it'll take long for the competitive juices to fire up once the judge convenes that jury.
I have to agree with you. And Georgia's dad, I think, was a FSU football quarterback. So she's literally as competitive as they get with that kind of pedigree. So it's going to be interesting to watch her matchup against Dan Rashbaum. Of course, Sarah Dugan will be alongside her. And we'll see how that all plays out. So let's jump into, there was a bunch of motions filed last week. I think there were 3 by the defense and then a couple by the state. So some of this stuff gets a little bit in the weeds, but I wanted to go through this and make sure we're all understanding exactly what's happening. So without further ado, I'm going to bring this up. Don't worry, the font gets bigger, but this is defendant Donna Adelson's motion to hold trial in courtroom 3B. So this is interesting. Dan Rashbaum made it very clear in the last court appearance that he does not want this trial held where Charlie Adelson's trials and the other ones were held, which is 3G. He wants it in 3B because 3B is much smaller. So he says here, the decision to use courtroom 3G was, as we imagine, a response to the public's demonstrated interest in this case and in keeping with the Florida Supreme Court's position that the public should generally have unrestricted access to all judicial proceedings. And he's citing a Miami case there. As the Supreme Court has made clear, John Singer, however, the public's right to access is not absolute, but must yield in order to protect a defendant in a criminal prosecution from inherently prejudicial influences which threaten the fairness of his trial and the abrogation of his constitutional rights. I'll stop it there. John Singer, this is where the law becomes really interesting. I mean, it says here that the public's right to access is not absolute. This is why we have judges, I assume. But how do you delineate that line? And I mean, Rashbaum's doing what he needs to do here. Do you think he's going to win this this motion?
So I guess this motion has engendered the most amount of interest, I would say, in those who follow the case for a variety of reasons. But the judge is going to have to employ your quintessential balancing test here between, the public's right and the defendant's right to a fair trial. So it's going to be a balancing test, as many of these pretrial motions necessitate from the trier of fact. So I don't know the difference between 3G and 3B. That may be a better question for Stephen, or even for you, Joel. You've been there. I don't know what the size difference is, but I don't think they're going to win that motion. The public has a right to see the trial. There's a groundswell of antipathy towards Donna, and I'm sure that the Adelson supporters are outnumbered by 10 to 1 or 10 to 0. So, the more people that show up, I guess the worse it is for Rashbaum and his client. But I'd have a hard time believing this motion would have any success.
Always great. It's always a great day, Neuropsych says, when John Singer shows up. Best guess indeed. Stephen Webster, I got to be honest. I was in 3G. I don't think I ever peeked into 3B because I had no reason. But I assume that you've probably been in both. Do you recall? I mean, is 3B? Do you have any idea how much smaller it is than 3G by any chance?
I mean, I'm just guessing here, but it's probably at least twice the size as far as the gallery is concerned in 3G. 3G was, they renovated the kind of north end of the courthouse. I guess it's been 15 years now, or at least 10. And so it's one of our state-of-the-art courtrooms, kind of, quote unquote, more technology, under the floor, stuff like that. But I'll be honest, the acoustics in 3G are problematic for me. I don't have the greatest hearing. I did a lot of construction work in a prior life, and if there's like when the air conditioning would kick on, if there's background noise, I can really struggle to hear what the jurors were saying sometimes when we were picking juries. So if they would have come with an argument like that, it would have been far more compelling to me. I genuinely don't understand the prejudice here that they've expressed or outlined. So I feel like it's a nothing burger.
Webster, what made you switch from construction to law? It's a big switch.
I had a friend who got accused of a crime he didn't commit, and it changed my trajectory.
Wow, that's amazing. And where's your friend now? He's
down in South Florida. Very successful mechanic, BMW mechanic.
Nice. So he was he charged with the crime? He was charged with a crime, but he was acquitted?
He was charged with a crime. His whole life upended, 2 years house arrest, and just really onerous pretrial release conditions. I was going to school at night trying to finish my degree just so I could put a degree on the wall and preach to my kids about going to college. And literally, I took my last night class Thursday night. They went to pick his jury Friday morning. I know now what happened. They had filed a motion to dismiss. The judge called it up at jury selection, and that's kind of a power move by the court to try to squeeze you to take a plea right up until the last minute. Called the motion up. I got off work and called and found out that it had been dismissed. Went to his party that Friday night, and his public defenders were younger than I was. And he came over to hug my neck, and I said, "I'm applying to law school." And he said, "Okay, whatever." And so I did. And
wow, that's an incredible story. Knowing you, it doesn't surprise me, but a great story. STS Nation, please feel free to ask questions, because some of these motions are going to definitely get a little weedy, as I said. There's a question here, which I think the answer to is going to be a definite yes. But Anna, if you want to jump in here from Linda Lou, is Wendy going to be called as a witness? She's almost sure to be called as a witness. And last time she was called, I think the first or second day, John Singer might remember exactly, but it was early on. Are we going to see that again in the same type of sequence, do you think?
Yeah, I agree with you that she will be called. I think she has to be called. She's a key part of this whole story. What order she'll be called in, that's hard to say. I do think that, again, because this case has been tried, so to speak, different defendants, right? But the case itself has been tried now. This is going into the 4th time, right? And so I think the trick with Wendy is she is really difficult for the prosecution. And in particular, if she potentially is going to get charged in the future, which I think a lot of us have thought may be coming down the pipeline. It's hard to tell. Like the first time they called her, it kind of seemed like maybe they were on her side. And then it started to get clear that they were thinking, no, she's probably involved. And now it's pretty clear to think she's really involved. And so the thing is how do they question her? What do they get from her? Is it going to help them in this case, but maybe hurt them in her case? So she is a very, very tricky witness for the prosecution. But that's my long way of saying, yes, I do think that she will be called.
The question is, she wore the same dress for the Magbanua trials and a different one for Charlie. So we'll see what the outfit will be. Lena Trail, look at this, John Singer. Hello from Zimbabwe. We are indeed an international show. Rosemary Romero with this question, and we'll get back to the motion. John Singer, you're excited that there could be more evidence. Are we going to see any more evidence to come out from Donna Adelson that we haven't seen?
Oh, sure. And I think we saw that in Charlie's trial. There was a number of text messages we hadn't seen or heard about previously prior to Charlie's trial, and I assume the same thing will happen in Donna's case. A lot of the texts that they actually used in Charlie's case were between Charlie and Donna, so those we'll have seen before. But there's bound to be new evidence. It's the same story, same conspiracy. The majority of the witnesses will be the same, but there'll be new wrinkles, different nuances. You've got a different defendant here, although one that's very tied inexorably to the other ones.
Tennis Girl 101, friend of the show here. Do any of the guests, Webster, will toss this to you, know why Charlie, of course, Donna's son, is on the list? I had heard state does not need him, but he's being transported. They're going to bring him over in case they want to call him, right?
Yeah, I don't know that I have a good answer to that one. I mean, maybe there's an outside chance that after spending time in the Department of Corrections and the conditions he's in, and if his mom is convicted, maybe Charlie would want to come to the table and talk. I don't know. And maybe it's nice to have him close to the table if that were to occur. But I've struggled to understand the strategy there.
I'm going to get back to the motion in a second with Anna, but John, another question here from Tom Dallas. Where is the smoking gun that shows Donna knew of the conspiracy when she made the Best Buy appointment for Wendy? Wiretaps do not prove she knew in advance, just that she went along afterwards. John Singer, you're in the courtroom. What's your response?
Yeah, I don't think there's a smoking gun vis-a-vis Donna, nor did I think there was one vis-a-vis Charlie in advance of the murder, but it's really what happened in the aftermath of the murder. Vis-a-vis Donna in particular, you have the checks that she signed from the Adelson Institute to Magna from September of 14 all the way up and until the arrest. You have her admissions on the wiretap about the matter involving the two of us, the two of us being Donna Adelson and Charlie Adelson. There's all kinds of evidence after the fact that shows that she was an integral part of the conspiracy. Prior thereto, I don't think you have evidence, any sort of smoking gun showing she was aware of it. I mean, you have the volley of phone calls, you have all the calls during the dates in question between Magna and Charlie, Charlie and Donna, and then of course Magna to Sigfredo Garcia. So you have that, that cascade of calls, which seems to heighten during the important dates in question, the first Tallahassee trip and the second Tallahassee trip. But like any other circumstantial case, this is about piecing together different bits of evidence and amalgamating them into one and asking the jurors to use their common sense, not check it at the door, but use it and ascertain whether they think beyond a reasonable doubt that she was involved in the conspiracy. And there's so many pieces of evidence that support her guilt that you don't need the smoking gun in advance of the murder.
There you go. You heard from John Singer. You don't need to have the smoking gun. So we were just talking about this. The Supreme Court has made it clear about the public's right to access not being absolute. And then on to this part here, to Anna, this is all having to do with switching the courtroom. And Dan Rashbaum writes, someone in the gallery took a photograph of a note passed between Charlie Adelson and his counsel on the second day of jury selection and proceeded to post that note on social media. While the substance of the note was unrelated to Mr. Adelson's case, the reporting in the media speculated about the note and its importance. Moreover, the fact that it was photographed and released for public consumption forced defense counsel to modify how and when they communicated with Mr. Adelson for the duration of his trial. What about that, Anna? I mean, he makes a point. I'm assuming that this did happen, but I don't necessarily understand how a smaller courtroom would prevent that, except for maybe you'd be more, intimidated to take your cell phone out, which is a big no-no. And there's a couple of moments in that trial, and I was there when people were asked to basically leave the courtroom, including one time with Ruth Markel, whose Apple Watch went off and they didn't know it was her. And, it was kind of a difficult moment to watch, but it was a totally unforced error and innocent mistake on her part. But what about this?
I have to say, I agree with what has been said so far. I'm not exactly sure. I would understand this motion more if the motion was either to close the courtroom or to restrict the number of people allowed in the courtroom, because the examples given are good examples to potentially do that, right? You're not supposed to have the audience interfere with how the trial is proceeding. So I would understand it if it was changed slightly. I too am having a hard time understanding why the size of the courtroom would make such an impact, unless you were to tell me only 5 people could be in one and 100 could be in the other. Then of course I could see it, but my understanding is it's not that extreme. So I'm not really sure how this changes that. I just, as sort of an educated guess, I think that this is probably the defendant being uncomfortable being in that same courtroom for obvious reasons. And so they tried to come up with a way to get out of that courtroom.
Yeah, I mean, obviously it brings back bad memories. She wasn't there. Neither she nor Harvey were present at Charlie's trial. But then it goes on here, Stephen Webster. One of the jurors stood up, this is according to Rashbaum's motion, in the middle of the examination and signaled to the court to stop the proceedings. After the court spoke with the juror, we came to learn that individuals in the gallery were making facial and hand gestures toward the jury in an effort to convey opinions of the testimony, which were distracting at least to the one juror who complained of the incident. That one juror, by the way, ended up being, we believe, an alternate juror. He was kind of making some strange faces the whole way through. But I mean, Stephen Webster, these are salient points, but I guess the bigger point to be made is how does it change vis-a-vis a smaller courtroom as opposed to, a larger courtroom? Does it just make it more uncomfortable for someone who's willing to take a risk doing something stupid because they know there's a better chance of them getting caught? Does this make sense to you?
I mean, obviously if that occurred, it would be concerning. But it would indicate to me the need for more kind of actions from the bailiffs. The bailiffs need to be more involved in kind of policing the gallery. That given that the public has the right to attend, these are public proceedings, and the public's right to attend these court proceedings is an important right that the public enjoys. So like John was saying, when you're doing the balancing test here, one outlier of an incident that you point to in the other trial that you can't identify any prejudice that actually flowed from it, and that won't necessarily be eliminated just by a smaller courtroom, and really should have been kind of fall more in the auspices of just the bailiffs running a tighter ship if that really did occur. I just don't see how this rises to the level to justify something this drastic. I mean, these proceedings are incredibly important to the city of Tallahassee. Okay. Like, you murdered Dan Markel, an FSU law professor in Benton Hills. And it literally tears at the fabric of this city. And given the circumstances surrounding it, given how hard law enforcement has had to claw and fight to bring the evidence to the table and to collect the evidence, and given the public pressure that has existed and the outcry for justice that still burns hot in this city, these examples to me don't get anywhere near the level of evidence or prejudice that you would need to demonstrate to me in order to basically curtail the public's right to participate in these proceedings as witnesses and to watch and observe as justice is hopefully delivered to those responsible.
Yeah, and Webster, when do you think we get the judge's ruling on these motions? Next hearing or before then?
I mean, I wouldn't imagine that it would take Judge Everett a long time to consider this particular motion. I mean, I feel like that he would, first of all, court administration is going to have to start making arrangements. If they're going to try to go to that other courtroom, they're going to have to make arrangements for technology and for, videos, things that at this point they've got down pat in 3G. So I would expect him to rule on this one at least sooner rather than later, so that there's no mystery for the court personnel, if nothing else, as to how it's going to, the logistics of it.
And again, they were filed different times last week. Thank you, Penny Green. Glad to be back. And then Magbanua, not Magbanua, from Susanna Matingu. A lot of, I don't know what their syllables maybe. Look at this. Hi from Dunkirk, France, followed by live from the UK. It's late there. I can't believe people are up that late. But I'm a night owl, so I kind of get it. John Singer, let's look at this next one right here. There's a risk of a larger live audience creating a sort of mob mentality in regard to reactions to testimony. By limiting the size of the audience, this court limits the probability of emotional outbursts and reactions in the gallery. That seems like a bit of a stretch. I didn't hear any emotional reactions really the last time around.
Sure, and I think it calls into question, the judge's ability to control his own courtroom, which I don't think is a valid point to make by Rashbaum. That's a dangerous one as well. Because
But what happens with that dynamic? I mean, you're inside baseball there. Judge Everett gets this. Does he get annoyed thinking, hey, this guy doesn't think I can control the courtroom?
I don't know if he gets annoyed. I mean, I think that, maybe part of him does, but at the same time, I think he realizes that this motion is just a reflection of the fact that there's no supporters for Donna Adelson. I mean, if Harvey comes, she'll have one. Maybe Ben Graber, although he might be sequestered, but no one else supports the Adelsons. So what you have is a number of people in the courtroom, all on the other side, all rooting and hoping against you. So it feels like, I'm sure Rashbaum filed a motion saying, you know what, I just want a smaller number of people in there hating my client than a larger number. That's really what this is. And I think the judge is going to see through it, deny it. I think Stephen articulated very well that the community has a strong interest, the public does, in seeing all the perpetrators brought to justice, and ultimately that's going to outweigh any of these prejudicial arguments that Rashbaum is really grasping for here.
And by the way, tomorrow night we're doing the 5 most damning pieces of evidence against Don Adelson with another stellar panel, including Jared Ross, who is an FSU graduate of the law school and undergrad, and an attorney and a lobbyist in Tallahassee. But we'll talk about the 5 most incriminating pieces of evidence against Donna Adelson tomorrow night, same time, 7 p.m. Back to you, John, on this. I think you addressed this in an earlier show. Do you think Robert Adelson is going to be called for this trial? He's, of course, the estranged son. I think last time you said there's no real need for him. Do you still stand by that?
I think there's no real need for him, and I think there's nothing he can offer in the way of anything tangible. It would just be conjecture on his part, and we already know from the Over My Dead Body podcast what he thinks about his family being complicit here. We know he thinks they were. We know that's one of the reasons, if not the reason, why he's estranged from them at this point. So all it would be conjecture. They kept him out of this conspiracy. He had nothing to do with it. And if they were going to call him, they would have called him in the last trial, right? They would have called him in Charlie's trial, because you have to think that he has more animus towards his brother than he does his mother. But again, there's nothing concrete. It would only be speculation. It would be inadmissible.
And John, you're on a roll here. Non-rev life in Maui. Will it be difficult? Word on the street is that Wendy has rented her condo here for $5,000 a month, and she's taken off to Austin, Texas. Is there going to be any problem getting her back to Florida to take the stand, John?
No, one state a subpoena from one state can be enforced in another state. I mean, I run into this issue all the time in my practice because it's all arbitration, or virtually all of it is arbitrable, other than those that seep through because they're discrimination cases into court. But the arbitration cases are really hard to enforce the subpoenas because you're not dealing with judges, you're dealing with arbitrators, sometimes not even lawyers, and they have a hard time enforcing subpoenas that are out of state. But here, no, this will not be hard, and she'll be testifying. They need her. She can offer up all the evidence. Stephen knows this better than I do. She can offer up all the evidence on the nastiness of the divorce. The divorce file is replete with filings that are very important to the state to show the motivation to get her, and most importantly, to get the kids to South Florida. So she's needed. She'll come. This will be number 4, and we'll hear different stories from her this time, because in each of the prior 3, she's oscillated somewhat from her prior testimony. So she's always an interesting one on the witness stand.
I love Singer's vocabulary. Just the only time I've ever used oscillate is with a fan, but Singer will get it in there under any circumstance. So Anna, to you, this is the end of this motion as far as we're concerned, but Dan Rashbaum goes on saying it's going to threaten her ability to secure a fair trial and risk a mistrial, which no one wants. I mean, what's the bottom line from you, Professor? Is this motion granted, or do they say see you later? Does the judge say see ya?
No, the motion's denied, and what he's doing is he's making sure that he's got a record, so that if there is an outburst, he can then make his motion for a mistrial. If there is an issue, he makes his motion for a mistrial. And again, he's just keeping that record, because if there is a conviction at the end of this, we know it will be appealed. And this is all part of thinking about what that appellate record is going to look like.
That's interesting. So, in other words, he's got to file these motions almost from a legal malpractice standpoint, that he's doing everything he can in the case that something does happen. He's got his I's dotted and his T's crossed, correct?
Absolutely. So if you don't, as a lawyer on either side, but in particular for the defense, if you don't say anything, if you don't object, if you don't make the motion, you can't then bring it to the appellate court and say, oh, well, I should have said X. I should have asked for the trial to be moved. I should have said that the audience was interfering. They don't care about that. They've got to see that you asked for it and that it was denied. So that's what he's doing. And then, of course, if he asks for it and it's granted, then he actually gets what he wanted. But I don't see that happening.
Stephen Webster from Rosemary Romero outside of Toronto. Is Harvey going to be testifying for the defense? Are they going to call him basically as a character witness to say, look, my beloved wife is a great mother. She's a great grandmother, not a great grandmother, but a great grandmother. Any chance that that's going to happen, or is that just going to ring hollow to jurors?
I don't think it's likely. I don't know what Harvey's current physical, mental state is at this point, and it just seems to me like that any value that he would add would also be fraught with peril. I mean, it's the same man who was booking, one-way trips through Dubai to Vietnam with her, was on the runway or the gangway caught with her. I can't imagine a scenario where it would be worth any risk of putting him up there. If he got up there and cried and everything else, could it maybe tug at some heartstrings? Maybe, but I just don't know in the grand scheme of things that it would ever be enough to move the needle with any juror.
John Singer, Wesley John Holmes comes to us from Tokyo, but he's originally an Aussie. He says, and he's been following this case more closely than you, I think, Singer. There's more circumstantial evidence, he says, for Donna than Chuck's trial, if that's at all possible. Do you agree with Wesley John Holmes there?
I think he has a point in the sense that the checks that were written from the Adelson Institute to Catherine McManua in the aftermath of the murder, that's an extremely potent piece of evidence against Donna. You also have Donna's emails in advance of the murder during the divorce proceedings, the extraordinary vitriol, the extreme amount that she was unhinged in those emails, and which of course manifested her extraordinary desire to have those children back in South Florida. That's quite powerful for the motive. So, in many ways, the evidence is as compelling, if not more compelling, against Donna than it is against Charlie.
There's a STS poll here. Do you think a change in courtroom would impact the trial? Doesn't matter. It's just a distraction. Overwhelmingly, the response at 82%. John, any chance, I just saw something here, of a postponement or continuance, as you lawyers say, with this trial? Or you think we're going full steam ahead?
I think we're going full steam ahead. The witness lists are in, the exhibit lists are in, all the pretrial motions have been filed, the motion to dismiss the indictment, the motion to suppress certain evidence, the motions in limine, which is a fancy way of saying that the defense wants and the state both want certain pieces of evidence to be excluded from trial. That's all been done. The judge has indicated we're going full steam ahead. So unless something extraordinary were to occur vis-a-vis health of one, God forbid, of one of the lawyers or the defendant or even the judge, I think we're going forward.
I'll tell you, one of the interesting things about being a quote unquote journalist is at one point I was asked to cover the stock market from the New York Stock Exchange, one of my first on-air jobs, and I had no idea what I was doing. But I learned business. I learned the lingo, and I've been reading a lot of these motions, so I feel like I'm learning the law. I was forced to be a political junkie when I was in DC. Not my favorite topic. Much rather be covering true crime. Politics has gotten too crazy for me. But here's another motion on this is defendant Donna Adelson's motion to dismiss the indictment for pre-indictment delay or alternatively to exclude evidence. So we get into the details here. Respectfully moves this court for an order dismissing the indictment for pre-indictment delay, or in the alternative, precluding the state from introducing exhibits or testimony at trial that she can no longer adequately refute. Can you kind of put that into English for us? What is he asking for?
Sure. So there's basically two things. He's done this in the alternative. Again, a smart approach to this, because we're thinking about not only hopefully getting what we want, but preserving that record for appeal, right? Every single time you got to think about, am I asking for something? And if it gets denied, can I then bring it to the appellate court's attention? And so that's part of what's happening here, because the chances of the judge actually dismissing this case is slim to none. However, I do think this is actually a very interesting motion, because although I think the chances of the dismissal for pre-indictment delay are just, it's not going to happen, I think it's a very interesting request to say to the court, listen, this case has been going on for so long, and the state has been aware of this information, and more importantly, of our client as a potential defendant for so long, and they chose to wait. And by waiting, they made it so that it was harder for us to do our own investigation, for us to come up with our own evidence. Is a very creative argument, and not just creative, but it seems to have some teeth to it. And so that's really what they're saying. They're saying, you took so long to charge me, and now I can't fight this because so much of the things that I would have tried to get no longer exist.
And can I jump in there for a second?
Please.
I just want to amplify something what Anna said, which is critical here. Here's what they're focused on, the defense, and this is really important. There's a text message that we saw in Charlie's trial that we had not seen in the prior two trials. And the text message was from Donna to Charlie on July 18th. So the evening of the murder was in the morning on the 18th. In the evening, the Adelsons were driving from South Florida to Tallahassee. They arrived there on the 19th to support Wendy. The text was from Donna saying, we're right outside of your house. And Catherine Magninua testified in conformance therewith that Charlie had told her that just before she arrived, Catherine arrived on the 18th, the Adelsons had come by with literally washed money. Like Donna Adelson had literally washed the money, and it was wet and damp. That is extraordinarily powerful testimony and evidence against Donna. Now, Raschbaum's retort to that is, no. Donna wasn't right outside the house. The Adelsons were driving. She and Harvey were driving to Tallahassee. They weren't right outside the house. They were simply passing by the house, and that they were never there the evening of July 18th. So what Donna is saying is, had you charged me earlier, we possibly could have gotten the cell phone tower pings to see exactly where the Adelson vehicle was on the evening of the 18th. So you shouldn't let that text message in. It's prejudicial because we're missing the opportunity to garner exculpatory evidence in the way of cell phone tower pings, et cetera, which are no longer available because 10 years have passed since the murder. This is critical.
Yeah.
Critical.
Very, very, very good and salient point there. And they're also, I mean, Raschbaum says not just cell phone pings, but also the fact that the SunPass records no longer exist. You took that long to charge, so we can't go back and show you that
Right.
Donna was not there. He claims again, like you did, that she was traveling at the time that Katie Magninua says she was dropping off the money. Does anyone have any idea why she washed that money, by the way, John? Do we know? I mean, is there any was it to like literally like wash her DNA away? Do we know?
I mean, I think in many ways, this was a very sophisticated and intricate plot, and in others, it was, amateur hour. These are not hard and fast criminals. The Adelsons, I mean, they committed a heinous and horrific criminal act, but I don't know if they're criminals in the sense that they have a repetitive pattern of criminal activity. So perhaps they thought that washing the money would eviscerate all traces of DNA and fingerprints. But, there's lots of mistakes that were made here. When you have a plot like this involving so many different individuals, there are mistakes, and thankfully there were, so that all the perpetrators can be brought to justice.
KCL with an interesting comment, which I'm going to get to in a minute, but Stephen Webster, this motion by the defense. We anticipate that the state will present evidence through Tallahassee Police Sergeant Christopher Corbett. His name has become popular as of late, of calls and text messages clustered around events of obvious significance, the murder in July 2014, and what the state has characterized as the first murder attempt in June 2014. The earlier patterns would prove that whatever Mrs. Adelson's communications were around the time of the murder, they were part of a larger pattern of calls and text messages between a mother and her family, not a murder conspiracy. Basically, Rashbaum wants, if they're going to do this, to widen out the timeline even further, to go back even further to show there was nothing sinister here. How do you see this through your lens as a defense attorney?
Well, in Florida, state attorneys have enormous discretion in when they charge and what they charge. The separation of powers is strong in that regard. For years, there was only one case, and it may still be the only case I'm aware of, where a defense of selective prosecution was upheld by the District Court of Appeal, where it was a politician and she was charged with a kind of a homestead violation. And she was able to show that there were 70 other people in the county who were, theoretically guilty of the same charge. She was able to show that the person she was running against was good friends with the state attorney at the time, and her case was dismissed and upheld on appeal. But normally speaking, the state attorney has enormous discretion in what they charge and when they charge, and the courts will not interfere in that. And that also holds true with how law enforcement officials conduct investigations. The police don't have any duty to a defendant to marshal evidence that the defendant would want them to marshal and collect. And the only exception to that has been kind of recognized with respect to DUIs. Like if there's a policy in place that, for instance, says that if they're going to conduct field sobriety exercises, they have to be recorded on a dash camera or a body camera if available, and then they fail to do that. We had instances where it appeared certain police officers were actually walking off screen away from the dash camera in order to conduct FSEs, field sobriety exercises, then coming back and saying that, they failed to touch heel to toe on 7 and 10 and whatever. And so the district courts of appeal have said, look, if there's a policy in place that says you have to marshal and collect evidence in a certain way and you fail to do so, it can be a denial of due process. But generally speaking, just because you would have preferred they did the investigation a different way and they would have collected this evidence that way, it's not enough in Florida, at least, to bring forth a claim of denial of due process, unless you could prove that it was intentionally stale. So, there are examples where it's within the statute of limitations where a particular defendant was located and there was a warrant for their arrest and they just didn't go effect the arrest. In those circumstances, a defendant can come in and say, look, you sat on this warrant for 2 years. As a result, now I don't have witnesses that could have been available for me. You knew where I was at. I wasn't hiding. That's another example where the court will kind of peer behind the curtain of the charging decisions and the investigatory steps that were taken. But in this case, I don't think anybody can reasonably assert that law enforcement was not diligently working this case. From the day it came in, they were working and they haven't stopped, frankly. Is there some strategy involved in when they charge certain defendants? I mean, yeah, absolutely. I mean, and certainly that maybe somebody would flip along the way. And at which point they would have come in one fell swoop. The points that Anna makes are well taken. And the arguments about the phone records, look, it's an argument they can make to the weight of the evidence. They can stand up and they can cross-examine the heck out of law enforcement on that. And I'm sure the judge will give them wide latitude to do so. But to suggest that somehow that should justify striking evidence, that really does smack of some sort of bad, deliberate, disregard for somebody's rights. And I don't think that this record is going to support that.
KCL here, she went there, John Singer, so let's go along with her. Will Wendy be a witness at her own trial? If not, which witness would share motive? Interesting question, John.
Yeah, I think it's a very interesting question. I do think Wendy would testify at her own trial. If nothing else, the Adelsons have been consistent and predictable. Charlie, we knew, would testify. We know Donna's going to testify, and I'm sure Wendy would as well. In that case, the two individuals who were enmeshed in this nasty and really, really horrific divorce. One is no longer with us, and one would not be invoking her fifth because she would testify. So they'd be able to get in the same sort of records with her that they've gotten in the first three trials, that they're going to get in with her and Donna's as well. It would just be under the auspices of cross-examination as opposed to under direct examination.
Got your 6 here. I personally think that Donna is going to testify and Georgia will make her lose her you-know-what, no matter how her attorneys work with her to stay calm. As per her phone calls with chuckles, they don't like Georgia. Anna, what's your thought on this? I mean, Donna had to be kind of hushed down by Judge Everett at her first appearance in Tallahassee. Georgia can definitely, she has it in her to rattle anybody. Are we going to see a meltdown potentially? Thought Charlie handled his testimony really well, albeit too rehearsed.
Yeah, I mean, I think this is one of the hardest things about being a defense attorney, which is advising your client about whether or not you think they should take the stand. Ultimately, it is the client's decision. And when you have a client that's going to take the stand, making sure that they're really prepared, what does that look like? And one of the biggest things is not getting rattled, right? One of the things that I always tell my clients is, I want you to respond the same way to the prosecutor that you respond to me. So if you're being respectful, hopefully to me, and maybe you're calling me ma'am, and the prosecutor is a woman, you should be calling her ma'am, right? That it's, you should be showing the jury that you were up there telling the truth, and it doesn't matter who's asking you the questions. And we've seen, right, both from the state's evidence when Donna was arrested, everything that happened after Charlie was convicted. She is highly, highly emotional for reasons that make sense. But either way, she's highly emotional. It appears based on the state's evidence, she was so emotional that she actually, killed her son-in-law and orchestrated, or her ex-son-in-law and orchestrated this whole thing. So she really seems to lead with her emotions. And that is a dangerous witness and very, very difficult for the defense to overcome that. So they might have a great case. They may attack all the state's evidence, put their client on the stand, and then lose the case because of the client.
That's interesting. Never thought about that. But Susanna Mattingu here. If Rashbaum argues Donna didn't know about murder ahead of time, Stephen Webster, he asks to explain Donna and Charlie's convos after. Agree? Number 2, does he stick with the failed double extortion theory? He can't ethically implicate Charlie. That's interesting.
Yeah, I do think that, and even the conversation between Charlie and Harvey at the restaurant, if Harvey didn't find out until that moment, it's why, kind of like all the cloak and dagger, and then how do you also explain there were "we're outside" comments? There's conversations to me that double extortion theory just never was going to hold water for me. And because of the conversations, because of the demeanor, because of the actions. And as far as sticking with it, I mean, I think they have to stick with it now. And I mean, as an attorney, I'm an agent of my client. And if I go into a proceeding that's similarly situated, and I make statements on behalf of my client in that proceeding, being it, saying that it was a double extortion, and Donna was the only one in on it, knew about it, how he could ever get up and represent in a subsequent trial that wasn't the case. I think it would be opened up for admissions by an adoptive admissions by an agent in the prior proceeding.
Joel, just to jump in, because I think Susanna, one of your viewers, asked a good question, and the first part was whether Rashbaum's going to advance the double extortion theory in this trial, and the answer is yes, he's going to. But the second part was, how can Rashbaum do so and ethically uphold his duty to Charlie, who he's no longer representing, but with whom he obviously did have an attorney-client relationship? The answer is he can, because Rashbaum is not going to opine, nor is Donna, on whether or not the first extortion actually occurred. What Rashbaum was going to adduce from Donna on the witness stand is that Donna believed her son when he told her that he had been extorted. Not that it occurred per se. She's not going to opine either way on whether or not the extortion plot had been effectuated. She's simply going to say, this is what my son told me. I believe my son. I trust my son. He was in mortal fear for his life. And henceforth, I had to write those checks, and so on and so forth. So the Rashbaum can thread that needle without impinging on any ethical obligations. Again, it's a ludicrous theory that has no truth to it, but Donna's not going to say whether or not it happened. She's going to say simply that she believed her son because it's her son.
Yeah, 100%. She's standing by him. Misbelieving. This is a interesting comment here. The irony is that Donna's obsessed with being in control, but can't control herself. Very ironic. Space Coast gifting 5 surviving the survivor memberships. Very generous. Spacey, appreciate that. Glad you survived the earthquake. L. Brooke Carpenter becoming a YouTube member. Welcome to you. This is the final motion that we'll kind of go through here because it's too much inside baseball. But Anna, back to you on this. Defendant Donna Adelson's motion. Yes, we will be airing this trial on the second YouTube channel, and I'll be there from jury selection to the verdict. We'll be up there live. Steve Cohen and yours truly will be there. Defendant Donna Adelson's motion to suppress evidence derived from wiretap interceptions. He does not want these wiretaps used. An order suppressing the April 7, 2016 orders authorizing the interception of oral, wire, and electronic communications over the cellular telephone number with call number boom, 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 and the cellular telephone with call number boom, boom, boom. We fully appreciate this court denied a nearly identical pretrial motion to suppress in Charlie Adelson's case. So he says, look, you already denied this when I did this with Charlie, but I'm going to try it again. Anna, to your earlier point, he's doing this for appellate reasons. I assume he knows he's not going to win.
Exactly, right. So it's anything that happened in the prior cases does not apply to this case, right? The record, we start with a clean record with every defendant and with every trial for that matter. So if there was a mistrial and there's a new trial, new slate. And so because of that, he has to make this motion to suppress. I mean, he's obligated to make this motion to suppress on behalf of his client, but he's also acknowledging the fact that this has been fully litigated in front of the court before, basically identical, that the court has denied it. And so he doesn't want the court to look at this and say, you're just papering me and you're wasting my time, but rather really saying to the judge, I'm doing what I have to do for my client, knowing that you're going to make the same ruling that you did in the other case.
It's just interesting to hear lawyers talk about papering. You got to be careful in each profession. You definitely do not want to annoy the judge. This chat feels like a family reunion. That's so sweet, Abby Crossing. Back for the first time in a week or so. Mrs. Adelson has standing to challenge the intercepts, according to Dan Rashbaum, and writes here, the move to suppress the contents of any intercepted wire, oral, or electronic communication or evidence derived there from on the grounds that, among other things, the communication was unlawfully intercepted, and aggrieved person in turn defined as any person who is a party to any intercepted wire, oral, or electronic communication, or a person against whom the interception was directed. John Singer, I have no idea what I really when you're in law school, do you learn to just read what you need to read, or do you read all this gobbledygook too, John?
The honest answer, it's you have to thread the needle, as we've been saying tonight. Yeah. But I think here, even Rashbaum here realizes that this motion has no chance, and the wiretaps have been admissible in the 3 prior trials. I think one of the things you didn't show on the screen was one of the motions that had been granted last time that Rashbaum had made regarding the transcripts from Dolce Vita. The judge in the last case had let in the recordings, but he didn't let in the transcripts. And obviously it's hard to hear. So the state really wants those transcripts to come in as opposed to having the jurors strain themselves and listen through the headphones. But that's another motion I think that was made. And I think Rashbaum will ultimately prevail on that one because this same judge already ruled that the transcriptions themselves were inadmissible, but obviously the wire intercept was admissible.
But why is I explain that to me? Why no transcripts? Like, what's the delineation there?
Well, it is difficult to hear. I didn't have those sophisticated headphones that the jurors had in the courtroom, but when I first listened to it, I read along as I was listening, and it is hard to make out some of the conversation. Obviously, they did a wonderful job enhancing it in Q1 of 22, which is what ultimately led to Charlie's indictment and eventually his conviction. But the enhancements only go so far. They're really hard to understand, and the transcriptions, obviously the defense wants to come out. They don't want those in.
By the way, later in the week, we're going to be doing Shanna Gardner, a very story with a lot of parallels to this one. There's some news that broke in that case. And we're also going to jump in to the Sarah Boone case, the so-called suitcase murder. That's happening in Orlando, and I'm going to try to get up there as well. It's going to be right after Donna's trial in October. And it's one of the things I'm trying to do in 2024, 2025 is actually be on the ground at some of these trials, at more of them, because you always get more, you get better info, and you're just more connected to the case. So that lies ahead for us. Meanwhile, jury selection is ahead of us in about 28 days or so. Stephen Webster, what kind of challenges are there going to be with jury selection with Donna's trial? Obviously, it's incredibly high profile. Tallahassee is a small knit community. What sort of issues do you see coming up with that?
I don't know if Judge Everett entered a pretrial scheduling order that kind of put parameters on the length of jury selection and how much time the court would allow. But there's no doubt that there's a lot of folks in this town that are aware of this case, and I'm sure that, that's going to be kind of painstaking going through, parsing through what do you know, where did you learn it, can you set that aside and only rely on the evidence that's received here in the courtroom. In Florida, at least, trying to get a change of venue it takes almost an act of Congress. You have to be able to show with studies and publications, and so we've kind of accepted the fact here in Florida that the venue is going to be where the venue is, and it's not going to be changed. So we're kind of used to, and especially here in Tallahassee. I mean, I don't know what's in the water here, but we've had some pretty high profile cases with a lot of publicity in the past 15 years. Adam Frash received an enormous amount of publicity here. There was another case, a Henry Segura case here that got quite a bit of publicity. Obviously, every iteration of this trial in this case has received a lot of publicity. So, thankfully, the courts have really kind of, I think, got it down to an art, seating a jury, even with the publicity. But, it's going to take some time. You have two fine defense attorneys. I've worked with Mr. Morris, Alex, for a lot of years. You can see, I think, from these filings, this is a very professional defense that these gentlemen are going to provide for Donna Adelson.
Well, Stephen, right here, it says Crazy Joe Lowe. These motions have Alex Morris's fingerprints all over them. We didn't see anything like this for Charlie's trial, as I recall. Do you agree with that? You think Alex Morris is calling some of these shots?
I absolutely agree that some of these motions have Alex's fingerprints on them. But as we just saw with that wiretap motion, Dan filed that one in the first go round. And he just, as Anna said, he's filing it here just to preserve the record in this particular proceeding. But there's no doubt. I mean, I definitely sense a little bit of Alex's personality coming in. He's a fine lawyer. And I think Dan is a fine lawyer. These are really professional, accomplished men. So, they're going to give her the same defense, and they're going to make sure that the jury selection is proper, and probably it's going to be onerous and ponderous at times, but I think we'll get our jury just as we did the prior times, and we're going to try this case in Tallahassee.
John Singer from Leap Day Boy, got to ask you, Wendy will be in lockup before Thanksgiving. Do you agree?
I mean, we've been through this so many times. I hope so. I don't want to predict either way, but I hope she will be. I hope that hope from the beginning that all those guilty would be brought to justice. I do believe she's in on it. And if she's going to be charged, I would hope they follow the same playbook they followed last time, which is getting Wendy in very close proximity to getting a conviction of Donna.
And as a little tease to tomorrow night's show, where we're going to be doing the 5 most damning pieces of evidence against Donna Adelson, what is your number 1, John Singer?
Against Donna?
Against Donna.
I think that the checks that she signed, especially in the manner in which she signed them, sequential, that's very damning. But, I think there's several pieces of evidence against her that all sort of have equal weight. Her admission on the 2016 wiretap after the bump had been effectuated, where she said it involves the 2 of us. You have a general idea of what I'm talking about. I think that the email she sent show the fact that she was so unhinged that she could engage herself in a plot like this. I think her admissions in the aftermath of Charlie's trial about the extradition, finding a country that didn't have an extradition treaty. I do think Rashbaum will try to spin that, but obviously it does evidence consciousness of guilt on her part. So, and also Magmanua's testimony about how Donna had dropped off the money, which is consistent with Donna's text to Charlie that evening saying, we're right outside your house. She doesn't say, we're driving on the highway or on the turnpike or whatever way you take to get to Tallahassee. She's like, I'm right outside your house. That means to the layperson that she's at your house waiting for you to come home. And Magmanua said that she did come into the house and gave him the money. So you tie it all together, you amalgamate it, and it paints a very bad picture for Donna Adelson.
Shout out to Asian American Legal Focus, who I see in the chat. She's been covering this extensively, and I think she's going to be at the trial, and hopefully us content creators will come together, do some shows together, maybe even up there. JWH to Anna, how much impact can information from the seized phones and tablets have on the trial? Now, we do know that they seized stuff at Miami International Airport. How big a factor is this?
I mean, it's a big deal. And as I was listening to sort of, the potential top 5, one thing that I think is really interesting about Wendy's case, and it's one of the things that really gets defendants in trouble. There's a phrase that I love, which is the only fish that gets caught is the one that opens its mouth. And I really think the state did not have a great case until Wendy started talking. Wendy started, when the bump happened and she really started talking.
You mean Donna? You mean?
Excuse me. I'm sorry. Yes, Donna. Sorry about that.
That's okay.
When Donna, right? When she starts talking, she's the one who's burying herself. And so the phones and the tablets, that's going to contain all this information. It's going to confirm the information that we have. And potentially there may be something that we haven't seen, but that's really going to show all those text messages, all those calls, all those emails that happened during the divorce where, all of that nasty stuff is most likely going to be on there.
This is a comment I don't see every day. I actually just took a photo of this from Billy Mayaya. Greetings from Lilongwe, Malawi, Central Africa. You ever been there, Singer?
No, but the show has global appeal. This case attracts everybody.
Unbelievable. Billy, email me survivingthesurvivor@gmail.com. I'm curious why you're interested in this case all the way over there. I'd be curious to hear from you. Maybe we'll get you on as a best guest one of these days. It is amazing how people are just super fascinated with true crime. Plea deals. One last thing that we'll just talk about, I think. But Stephen Webster, any chance of any last minute plea deals that you can think of in this, in this dynamic? You've got Wendy, you've got Charlie, you've got Donna, you've got Harvey. There's so much talk about Charlie potentially turning on Wendy. Those jailhouse calls, it seems like Donna is implying that Charlie is not too happy with Wendy. So what do you think as a best guess here about any potential plea deals?
I could see where it would make sense. I don't know how those deals could be structured at this point. unfortunately for the defendants, if there was an appetite for that, the best time to really explore those options was before trials and convictions. But I could certainly see where, and listening to some of the jail phone calls, where Charlie might be inclined to try to go out there and figure out a way to protect his mother. It's clear that he loves his mother. And it's clear to me that he's not happy with his sister. As he said, what are the odds? 1 in a million that she would ride by the crime scene. And if she rode by the crime scene and she knew, then that means I knew. And that also means mom knew. Like, you have to take that next dot and connect it. If Wendy going by the crime scene is evidence that Charlie was involved in a conspiracy to kill Dan, then you must also conclude that Donna was involved in that conspiracy, and Wendy's driving by that crime scene was proof of that as well. So, I do think Charlie cares immensely for his mother. And I could imagine a scenario where he might be willing to just, take the hit for her. But I don't think it's likely. I just think at this point, nobody beats the Adelsons. And I think every domino is going to have to kind of come down before there's any realistic chance of anybody coming clean on that side of the aisle.
And then KCL, obviously, mentioning just the two of us on the wiretap. That's also very incriminating. This is the funny comment of the night from Wesley John Holmes: is John Singer on the Star Trek Voyager? It's kind of does look like that. Anna Cominsky, she is the director of the Criminal Defense Clinic at New York Law School. She teaches courses. She also does the law there for the school. Anna, just your final thoughts, kind of open-ended here. Again, we're 28 days away. This is obviously a very highly anticipated trial. Court TV, all the other big outlets are going to be there. We will be there. Do you expect drama going down the wire before we get to jury selection?
Yeah, how much drama, I don't know. But yes, I'm sure there will be some things that come up, because things do come up, especially in cases like this. And, this is a case where there's a lot of emotion on all sides. There was a man who was murdered, and that's just awful. And so sometimes it's hard for us who are used to talking about this to remember that, someone died here. And so I think that we should expect this trial to be full of emotion and potential new evidence, the same way each of these trials have sort of, unveiled some new piece. And I would expect the same to apply here.
John Singer, this question is kind of interesting. Tom Dallas is, for lack of a better word, and I mean this with all due respect and love, harping about the fact that Donna did not know about this till after the fact. He says the involves the two of us doesn't look good. The right outside the house doesn't look too good, but the checks and payments over time aren't damning. Maybe Donna just went along afterwards. Your response to this comment?
I think that's consistent with Rashbaum's theory that Donna was told after the fact that there had been this extortion attempt on July 18th, that he had paid Magmanua money and that more money was required, and that he could only confide in one person, and that was Donna, and she believed him. She didn't ask too many questions, according to Charlie during his testimony, and she simply went along and wrote the checks. And the jury's going to have to believe this double extortion theory, or at least believe that Donna believed it, and it's just implausible. At the end of the day, jurors have common sense. They don't just check it at the door. That's a popular expression in our line of work. And 3 juries, at least 2, I should say, and the first one there was a hung jury, but in the last 2 trials, whatever the defense was selling, they weren't buying, and they won't buy it here. The one thing I did want to pick up on also was another comment about the Markels testifying. It seems unlikely to me that they would testify, although Ruth, in her wonderful book, which I've read a couple of times, I think it's so great, does talk about the sort of bizarre scene at Wendy's rental home on Aqua Ridge in the aftermath of the murder, whereby the Adelsons really were seemingly very paranoid. They were walling Wendy off. There was always someone around her so that she couldn't be really spoken to in private, and that Donna sort of felt that there was something I don't know if I would say untoward, but she felt that something was off during that particular Aqua Ridge gathering. she could possibly offer that as testimony, but other than that, I don't think we'll see the Markels coming to testify.
Leap Day Boy here says Wendy would be smart to make a deal. She's still young and has turned her back on her family. Then you see, by the way, Stephen Webster, one half of Webster and Baptiste, attorneys at law in Tallahassee. His other half, Louis Baptiste, great guy, both been on the show plenty of times and will be back plenty of times. Stephen was also Dan Markel's post-divorce attorney. I met Jimmy McNutty out in LA. Great guy. His two passions, trial watching and raising butterflies. This is why I love people. Very complex creatures. He says, Jimmy McNutty, to you, Webster, if Donna could take a plea and leave Wendy and Harvey free, do you think she would do it?
I don't believe so. Look, the vanity of these people, and it's really off the charts. And Donna made the comment that nobody beats the Adelsons or whatever somewhere along the way. And that really is what it is for her. I mean, they are going to remain cloistered to the rest of the world in their belief that they're innocent and that nobody's proven anything, and our family is perfect and wonderful. And I just can't. It's hard for me to see a situation where Donna does. I think it's more likely that Charlie would, if anybody would. Like I said earlier, I could see a scenario where Charlie looks around and says, "I don't want my mom to die in prison," and he may actually love her enough to step up and try to see it and explore if there's an opportunity to protect his mom. But I don't see Donna ever, short of a real major change in circumstance, coming forward and admitting that her family is really this evil and demented as we've all come, at least I've known they are, for 10 years.
Black Widow in the Republic of Ireland. Joel, buy your ma a membership, you tightwad. I don't even know how to buy a membership, but COE, get on that. Let's buy Carm a membership. Hi, Carm. Hi to all of you from Carm weighing in. Go out and read her book. It's not my book anymore. It's Carm's book. I think that'll help sales, actually. Carm actually wrote the book. So now if you don't buy it, you're, I don't know. I don't know. I don't know what I'm trying to say. Ohio Palm Mom. I'm so glad you'll see how the jury reacts. Yes, we will be there for that. And Rachel here letting us know, just tuning in and saw the COE and turned on my STS notification. 28 days. There we go. John Singer. He is co-founder of Singer Deutsch LLP, graduate of the Georgetown Law Center, is super lawyer, super guy. Singer, does your wife find your vocabulary as sexy as I do? That's question number one. And question, does she get tired when you talk with big words, like oscillate, or does she like it?
I mean, she's so much smarter than I am that I think.
Do you really think your wife has a higher IQ than you?
She's a lot smarter than I am. She's
really,
really smart, like off the chart smart.
Really?
Even Rashbaum had to admit that, because they went to Pinecrest together, and even he says, amongst other things, that Jen is an extremely smart person. So it's not just lip service. There's things she's not good at. But
that. By the way, look at this from KCL. I once kept track of all of John Singer's advanced vocabulary words on an STS show. I counted 23 advanced vocab words. I love learning from John Singer. I'll tell you a sweet story about my dad. When I was in 7th grade, he used to make me sit down with him a half hour on each weekend day, and we would read all the classics like Moby Dick. I remember The Birthmark by Nathaniel Hawthorne, Shorts. And you know what? It really helped me. I'm no John Singer, but I'm a little. But now I'm intrigued. Who scored higher on their SATs, John Singer?
She did by
really
a lot. Yeah,
really.
She's an 800 in math. She's like one of those people. Like she's a
really
Wharton grad. Yeah, I went to Tufts, which she thinks is a joke. She went to Wharton. Georgetown Law gets me nothing with her. It's it's one of these things.
I don't want to belittle you at all, but how did you scoop her up? How did you get her, John? Tell us the story.
Those records.
No one's listening.
Very sealed. I mean, I think some people find me, I don't know who. A couple of your listeners, but other than that, I don't know.
I'm proud of you, John. Now that It's nothing like an intelligent woman. I'm very proud of you. Singer, I'm going to leaving it totally open-ended. We're 28 days out. What do you think?
I think that, as Anna said, just to pick up on one of her last comments, that, it's right before the trial. There's always a flurry of activity. There's things that we're not anticipating, right? I mean, we've seen this movie now 3 times. This is the 4th, but there's always different wrinkles in these cases. So there'll be some pretrial drama of some sort, and I'm looking forward to seeing the new evidence. I do think that Donna is going to be more composed than some of the viewers think she's going to be. They've had a long time to work on her, and she's a smart person. And I think the Donna Adelson we saw in that first appearance with her prior attorney, that I think she's been chastened. And I think Rashbaum has impressed upon her the need to be grandmotherly, not volatile, to be demure. And I think she's going to be that. And she'll be a tough witness, I think, in a lot of ways. Will they eventually crack her? I hope so. Will they get a guilty verdict? 100%. But, she's not going to be easy on the witness stand. She's the smartest of the lot, of the Adelson lot, by far.
It's going to be super interesting to see play out. By the way, someone just said you've got movie star good looks, and I took a photo and already texted it to you, Singer, so you can show that to your wife. It is all about remembering Dan Markel, dad, son, and brother, FSU law professor, mentor to many, including Louis Baptiste, who is Stephen Webster's other half in the law. Abby Crossing asking how it was. Look at here. OMG, what was it like to meet Jimmy McNutty? I was a little starstruck. I'm not going to lie. Guy's biggest trial watcher in America. Got a little bromance going. It was cool to hang out. I wish we could have hung out a little longer. He asked me to sign a shirt. First person ever to do that. And I got to tell you something. I guess it's not easy being a rock star because I couldn't signing a shirt is very hard. It's not easy to do. Try to sign a shirt with a Sharpie. Very difficult. It took me a while, but I got it done. Look at this now. It's all coming. John is very handsome. Even someone, look at this. Peaches loves you, John. There was a comment earlier. We'll end with this. John Singer, what do you do if Peaches leaves a paw print on that beautiful couch of yours over your left shoulder? Yes.
I mean, I don't know why I'm admitting this because it's just going to, get everyone crazy again. But Peaches doesn't have the run of the house. She has a very limited area by which she's allowed to navigate. So, and she's well trained. She's a great dog. We love Peaches. Peaches is the best. Free Peaches, whatever you want, whatever tagline you want to use. We love her, and she's clean and neat.
By the way, we started watching last night. I always give Netflix should advertise on my show, but as the COE and I watched the first episode of Chimp Crazy. True story. I've always wanted a chimpanzee from like the age of 7. There was a chimp named Mr. Jiggs in the Catskills when I was like 7 or 8, and I met Mr. Jiggs, famous chimp, and nothing ever came of it. And then I watched that show last night and realized I could never own a chimp. It's made by the same people that did Tiger King, which Carm called Lion King, but it's depressing as hell because these people keep these chimps locked up in cages. Ned Smith, the last comment. Joel, you were mentioned on Peter Tragos' channel. That is the lawyer you know. Ned Smith, you got to email me, survivingthesurvivor@gmail, and let me know what he was saying about me. And I've got to now fire back. Mr. C, free Peaches. Peaches is in a cage. Here it goes. John's reputation sullied once again. Anna's like, what am I doing? This is unhinged. Crazy again. Love you, America. Love you, Tallahassee, Florida, New York City, where our other 2 guests are. And, of course, it's all about justice for Dan Markel. Tomorrow night, same time, 7 p.m. Eastern time, the 5 most damning pieces of evidence against Donna Adelson. And then Wednesday, Thursday, we're going to pivot to Shanna Gardner and Sarah Boone. Until next time. Guys, stick around 1 second.